The Age Discrimination in Employment Act makes it unlawful for an employer to discharge or discriminate against an individual because of the individual's age. An employee alleging discrimination under the Act must prove that age discrimination was the but-for cause of the adverse employment action. That is, her age had a determinative effect on the outcome of the decision. A plaintiff can establish age discrimination through either direct or circumstantial evidence. When using circumstantial evidence, the plaintiff must prove a prima facie cause of discrimination. She must establish she was a member of a protected class, was subjected to an adverse employment action, was qualified to do the job, and was replaced by a younger individual. Case of federal law, we're talking about an individual who was under the age of 40. If the plaintiff establishes a prima facie cause of action, then the employer must articulate a non-discriminatory reason for the employer's conduct. Now, if the employer meets that burden, the plaintiff must then demonstrate that the proffered reason for the termination was merely a pretext for unlawful discrimination. Alternatively, a plaintiff can present a convincing mosaic of circumstantial evidence that would allow a jury to infer intentional discrimination on the part of the employer's decision maker. That is, the plaintiff must make a showing by evidence that demonstrates, first, suspicious timing, ambiguous statements, or other bits and pieces from which an inference of discriminatory intent can be drawn. Secondly, systematically better treatment of similarly situated employees, that is, employees who are under the age of 40. And finally, that the employer's justification for its conduct is merely pretextual.